5 o'clock, so if we stop 5 minutes ahead of that, then you should have plenty of time to go in and get a seat. It'll be a very good presentation. I highly recommend that you attend. Okay, so today we're going to be talking about permitting processes, and we're going to get into some of the nitty-gritty details that are implied in the concept of procedural due process. And I'm working through my handy-dandy sheet here, and I see I have several people that I have yet to have conversations with. Craig and Nick, you are on my list. So you guys want to draw straws here and figure out who's going to talk today? The issue on the table is Fasano versus Washington County.
I might have to take pass today.
I'll go for it. Yeah, all right, there we go. Like you mean, no harm here. That's fine. Pass. Nick, Fasano versus Washington County. What's the beef? What's the dispute?
The main dispute here is Fasano is a residential neighbor in the area, and I believe it's AGS Development Company owns a piece of property of about 32 acres next to this residential owner. The land currently is zoned, well, the land was zoned R7, which was residential single family.
Probably 7,000 square foot minimum lots. It's what 7 probably means. We don't know for sure.
And they want to have it, at least the AGS wants to have it rezoned to PR status, which is, I believe, what did we call it? Planned residential, and that allows for higher density units, or higher density, and in this case, they're looking at a mobile home park.
And everybody wants to live next to a mobile. They don't call it that anymore. This is called manufactured housing. Mobile home just has too much negative associations. Manufactured housing.
And so the Fasanos go to the city council, and they're trying to get it appealed, or trying to not have the zoning take place. And due to that fact, the city council had heard, or not, the planning commission had heard originally from AGS, and the planning committee had voted it down. In turn, the city or the county commission,
Right. It's a county.
they actually said that it would be fine because I said the changing demographics in the area would constitute the change, and then the Fasanos actually ended up taking it to not to Appellate Court, I forget what it is,
Trial court.
trial court, and they asked for it to be for the zoning, which was changed, to be reversed. Trial court says, yes, we agree with that, and then after that, I believe the appellate court also said that they agreed with it, and then went to the Supreme Court.
Good. That was a nice summary. So just a bit of background. Washington County is roughly the western third of the Portland metropolitan area. It is historically been an agricultural county, but it's now known as the Silicon Forest because this is where many high-tech firms have been located in the past 30 years, 40 years. And so now it's the home of multiple industrial campuses for all the big chip manufacturers, and then the suppliers that go along with the chip manufacturers, and the people that assemble components using computer chips, and the people who do programming for the stuff that goes into the software that goes into the computer chips. And so it's now turned into this kind of mini San Jose. And like San Jose, they have a housing shortage. So the problem in Washington County is that a lot of the jurisdictions in the county itself, and then the cities within the county, of course, love all this industrial development. Why do they love industrial development?
Taxes.
Taxes, right. The property values for land that is zoned industrial in a growing economy where that land is in demand, the property values are substantially higher than, certainly than residential, even more so than retail. That's probably the highest value category that you could zone a piece of land, assuming there's a demand for that land, right? And of course, every local jurisdiction has very rosy assumptions about demand for industrial land. And so they see, we can make a lot more money in property tax revenues because you understand how this works, right? If property values are high, if the value of the real estate is high, that means that the revenue that they receive from property taxes is going to be much higher, and that makes the government very happy. And so they, in Washington County, have fallen prey to what we call fiscal zoning, which is taking huge swaths of their territory, rezoning it for industrial under these rosy expectations that it all will be developed and generating really high property values and then high property taxes, and leaving not very much for housing, and especially lower income housing. And the thing is about industrial, at some of these plants you've got people with PhDs and master's degrees, engineers and so forth who are working there. But you've got an awful lot of people who are working blue-collar jobs, right? And so finding housing that is affordable to the people who are living in the county is Washington County, continues to be Washington County's challenge. And as a result, a lot of people commute from neighboring counties because they can't find affordable housing in Washington County, even though that's where they're finding their employment. So, like San Jose, Washington County also has a traffic congestion problem. That's really, at its root, a housing issue. So here comes this developer who sees a strong market for affordable housing, because manufactured housing is one of the options that housing options that is classified as being affordable, and so sees this opportunity to meet a market demand, do something that's consistent with at least good planning and public policy, and so they apply for a zone change to take this piece of land. And this piece of property, by the way, is this is not centrally located in the county. This is out at the fringes of what we call the urban growth boundary, and we're going to learn more about that next week. In Oregon, the Oregon planning system requires every municipality or combinations of municipalities to have a regulatory instrument that defines where urban land ends. Land that's available for urban development is segregated from land that is protected for rural uses. And so this piece of land is right up against the edge of the urban growth boundary, undeveloped, and so the developer thinks, well, it's kind of not next to very many people, and so maybe it's a good place to put a manufactured housing project like this. Well, he just happens to be next to at least one cranky neighbor, and that's all you need to slow a project down. So Mr. Pisano files this action. Okay. So Nick, what ends up happening? At the end, I mean, the Supreme Court does what to the case? Does it overturn what the prior court said, or does it affirm it? Does it send it back to the county for more action?
From what I got out of it, I thought that they had just accepted what had been said.
Well, they ended up affirming the outcome that is done by that is reached by the trial court and then by the Court of Appeals, because the trial court overturns the county's decision. The trial court found in favor of the plaintiffs, disallowed the zone change, and reversed the commissioner's order. So the trial court sides with Pisano, overturns the county's decision to rezone this piece of property. The Court of Appeals agrees. The Supreme Court also agrees. but maybe on different grounds. We don't know exactly what well, actually we get a hint at what the other courts said as the reasoning for their decisions. What's at the heart of the Supreme Court's problem with the county's decision?
The thing that I got out of it was that the acts of the legislative body didn't. I really like the one part that they said in here.
Did you hear that? I really like the one. My kind of student. He's just.
It says, to place them in the hands of the legislative body, those acts as such are not judicially reviewable, is to open the door to completely and arbitrary government. In other words, what I got out of it is that if they don't, by allowing the legislative body in this case to make decisions based upon how exactly to say it, but by allowing them to make those, it would it's basically a balance of powers. The administrative body should be enacting the laws, and that the court could only be able to rule upon the things that because the legislative body creates the laws, and that's what I got out of the heart of it was that the balance of powers really would be frustrated if they allowed this to go through.
You're right on the money. Absolutely. What this case is all about is the difference between administrative and legislative actions. And why do we care about that? Because the processes that are required for those two different types of actions are very different, at least with respect to due process. And that's what the court's talking about here. There's a bit of a statutory interpretation going on here, but mainly what the court's talking about is what does the due process clause of the Fifth Amendment and the 14th Amendment mean in the context of local land use decision-making processes. That's what's at issue here. And we know a little bit about this because we've talked about it before, but now we're going to hit this issue head on. And the underlying question is, what kind of action are we looking at? What's the flavor? Is it administrative? And they use a different word, judicial or quasi-judicial. We've talked about that before. In Utah, we tend to use this word instead, administrative, but for our purposes, they are synonymous. Or is it legislative? That is the question. How had the county treated this? Did the county treat this as an administrative action or as a legislative action?
They did it as a legislative action.
Exactly. And if it is a legislative action, what does that mean in terms of process and standards?
The legislature, in this case, needed to go through the substantive due process to get it approved for the zoning change. And from what I understood, they kind of came to their own conclusions without following all of the due process
The procedural
laws.
due process.
Yeah.
Right. Yeah, so legislative actions, they have to, what? What do we know the requirements of substantive due process? They have to effectively promote or protect community health, safety, and welfare, A, and B, or number two. They have to be logical, rational, in other words, not arbitrary or capricious. It's a real minimal standard. I mean, occasionally you find, like in the Lingle case, the Chevron case, the Hawaii case, occasionally you'll find a legislative action that fails to meet this standard, right? Because it didn't effectively promote a health, safety, and welfare concern. And sometimes you'll find actions, and in fact, you'll find it even on the essay question in a midterm exam, where you get a body that seems to be making a decision arbitrarily or capriciously. And as many of you said, that's a violation of substantive due process. Good catch. But generally, not much in the way of standards, and even less in the way of procedure. When it comes to procedural due process, the kinds of steps that have to be followed, the processes that have to be followed, there's almost none. Think about it for a second. We just have survived another session of the Utah legislature. I think. Did anybody go up and spend time in the Hill? Mike, great. So, Mike, did you go to any committee meetings?
No, I didn't.
Okay. Anybody go
But
to
I have been to meetings.
You have been
in the
to
past.
committee hearings, okay. When you go to a committee hearing at the state legislature, were you given the opportunity to address the committee?
Yes.
You were. And did they give you any restrictions on what you could say, or how long you could say it, or?
I believe there were. I didn't actually get to speak because when that bill came up, the legislator that was sponsoring it decided to pull the bill. So there was. It went dead at that point.
Okay. He saw that you were there.
Exactly. I saw that I was there.
Oh man, Christensen's there. Forget it. Throw it in the towel. It's the Eye of Mordor. The fact that they provided you with an opportunity, even though you didn't come to it, with an opportunity to speak, do they have to? Can a legislative committee review and take action on a proposed bill without taking public testimony?
Yes.
Yes, they absolutely can. There is nothing in the Constitution of the state or the federal government that requires a legislative body, when taking action legislatively to adopt a new law, that requires them to hear from anybody. Do they have to be unbiased? Do they have to be a fair and objective decision maker?
Sure hope not.
Because they fail to do
Yeah.
terribly. Are they disallowed from talking to interested parties?
No.
Heck, that's where they get all their information from. They're called lobbyists. The due process clause has almost nothing to say. And I'll just go ahead and be extreme here. The due process clause has nothing, not almost, has nothing to say for procedures that have to be followed when legislative actions are being taken. And that is true certainly in the state legislature, right? But it's also true for city councils and boards of county commissioners, which is the case here. When they are sitting as a legislative body and taking legislative action, and city councils and boards of county commissioners do that, when they're adopting a new ordinance or an amendment to an ordinance sometimes, or amendment to the general plan, they're speaking, acting legislatively, and they may be required to take certain actions by their own rules, and the state legislature has rules about how they govern and how they conduct themselves. Or in the case of a city council or a board of county commissioners, there may be state statutes, like Ludmont, that specify that they have to do certain things, that they have to put notice in a paper of general circulation about the content of a particular scheduled meeting, that they have to provide an opportunity for people to address them, that the decision has to be made first, or a recommendation has to be made first by the planning commission before it goes before the city council or county commission. There may be a statute out there that requires all these things, and LUTMA does. And so please don't walk away from this discussion thinking that there are no procedural requirements for legislative actions. There are. What I'm talking about is what the Constitution requires, and that's what this case is about. What do the Fifth and 14th Amendments of the Constitution, the due process clauses of those two amendments, require with respect to legislative action, they require nothing. If, like I said, just to re-emphasize, if the body itself, the city council, the board of county commissioners decides to adopt their own procedural rules and put their own limitations on themselves about how they conduct business, legislative business, they can, and many of them do. And certainly anybody that gives them authority, like the state, right, because they're all operating under delegated authority that's delegated to them from the state legislature, that delegating authority, the legislature at the state level may specify certain procedures that they have to follow, and in this case it does. But, again, with regard to constitutional principles, apparently, our founding fathers and mothers, or maybe the mothers, they never got a voice. The founding fathers didn't give a rip. Now, if they'd given it to the founding mothers, they probably would have done something about this. But the founding fathers didn't give a rip about this. Why? Is that shocking? I thought we were all about fairness and democracy and, right?
Well, I've been listening to a documentary about Alexander Hamilton, and obviously he wasn't one of the founding fathers who, wrote the
It's on the
Constitution.
$10 bill. It's
But-
not.
But he was later, and he believed that informed people needed to make the decision for the masses, without taking all their clamor. And so that kind of goes back to that same thing. It's like, the legislators are supposed to be informed. They can make the decisions for the masses without necessarily taking their comments.
Yeah. And what if they screw up? Yeah. And this is why. The due process the due process clause does not speak to this issue because there are other checks, potential checks, on possible abuses of power, and they're electoral. Because if you're taking legislative action, you are, by definition, taking action that will affect a broad swath of people, a broad swath of voters. And if that is the wrong decision, you will piss off enough people that they can band together and petition the government for a redress of their grievances, as it says in the Declaration of Independence. They can show up at the city hall with torches burning and pitchforks. They can sign a petition. They can come and present testimony and make proposals for changes in legislative decisions that they think are wrong-headed. And we can work through a regular political, electoral, democratic, maybe graphic too, process to right the wrongs. And if it gets bad enough, you can vote the bastards out of office. Right? And so that is the theory here, is that there is a check on this, that it comes through the electoral process. Yeah.
Doesn't that have something to do with the reason why we were founded as a republic and we're not necessarily totally a democracy? We don't democratically vote on every issue.
Right, we're a representative democracy, but it's still the remedy here is electoral, even in the context of a republic. All right, if we're taking administrative action, we don't have the same protections. Because if we're taking administrative action, we're usually dealing with a small group. We're taking administrative action, we're less likely to be developing new law, much more likely to be applying pre-existing law to some set of facts, some circumstance, some specific example. And in that situation, the electoral processes are ineffective to guard against bad decision making, right? Because if it's just you're the applicant for a particular project for manufactured homes for people who need them, low-income workers at these industrial plants. You're doing the right thing, making some money on the side. And these NIMBY neighbors, probably lawyers downtown, who live out there in the country on their martini farms, are getting in the way of your business and of this good work, right? And what chance do you have to stop? Not much. So, so what the Supreme Court is saying here is, okay, you've misclassified this action, because how many people are we dealing with here?
Supportive.
A limited number. The applicant and people who filed the court action against them probably appeared at the hearing. So a very limited number of people are being affected by this project. Is this the creation of a new zoning district? Nick?
In this instance, it's a floating zone, I believe is what they call it, with that PR, and they have to select a piece of property that they're gonna apply it to.
But the provisions of what's required and what's allowed in the PR zone, are those being created at this point, or they already exist?
I believe it was this case happened, I believe, 1979, or something like that, 1973.
Yeah. I think
It was actually, the PR zoning was created in 1970, so it was created before this happened. So it wasn't like they were actually creating something new. It was already a zoning capability that was existing. It just had to be applied to a certain piece of property.
So, in making this determination about whether a particular action is administrative or legislative, the Vizana court here is suggesting, implying basically three variables that are kind of on sliders, right? Meaning that they could be more one direction or more the other direction. They're not necessarily dichotomous. But the three sliders have to do with whether you're making law or applying law. I did this backwards. The number of people involved, number of parties, small number versus large number, and the amount of land that's involved. So this is number of people, and this is amount of land, and again, small amount in here versus large amount here. And depending on where you end up on these continua, the action that you're looking at will be more administrative or more legislative in its character. Usually it's pretty easy to tell. You know, if the PR district had not yet been created, if the applicant here was creating that district as part of this project, how would that have changed the calculation?
The legislature would have had to go on and create it.
This is the Board of County Commissioners. They are both a legislative body and an administrative body. So it's the Board of County Commissioners.
So they would have actually had to, if it hadn't existed, they would have had to create it, would have had to went through all the process, and then had the opportunity to be. So they would have had start off making.
They'd be making new law, right? They'd be creating a whole new district. They'd be creating a whole new section in the zoning ordinance, right? That is a legislative action, and especially because it's a floating zone, it potentially it could affect a large number of people and a large amount of land, but you don't know yet, right? And so probably, if this were the case, if this were hypothetical was actually true, if they had to create the district and then apply the district, we would really be talking about two different decisions, right? The decision to create the district and the decision to apply it. To create the district, again, we're talking about making law, potentially affecting a large number of people, potentially affecting a large amount of land. Clearly, legislative, few or no procedural due process requirements. There may be some statutory requirements that the state legislature is requiring them to go through, but that would be it. They still have to show that the action effectively promotes or protects the health, safety, and welfare and is not arbitrary or capricious. They still have to meet that standard. But that's pretty much it. Applying that zone to a specific piece of land, well, we've just used that word, right? They're not creating the law, they are making a zone change. They're changing the zoning ordinance, or the zoning map, really, is what they're doing. They're changing the zoning map, which is part of the ordinance, right? So technically it is an ordinance change, but it's, what you're doing is you're changing the map. For this piece of land right here, it's going from R7 to PR, right? But you're applying that already existing district. So you're really kind of applying law. It's only affecting a handful of people, the applicant and the people that live around it. And it's affecting one piece of property, or it's that property and maybe the affected property. So what the court's saying is, yeah, we agree with the Court of Appeals and the trial court that this needs to go back to the county. But the reason we agree it needs to go back to the county is because they put this in the wrong box. They treated this as a legislative action, when it really as an administrative action. And why are they concerned about that? Because they're concerned about the ineffectiveness of electoral checks and balances on the abuse of power. Because if there's just a small number of people that are being influenced or affected by the decision, small amount of land, what's to stop a misguided government entity? And I know you don't believe that there are any out there, but I tell you, I've seen one or two in my day. Someone was asking me today, so do you know a lot of planners in Oregon? I said, sure. I used to sue them all the time. I was never a very welcome guest at local chapter meetings of APA because there were so many people around the room that, well, it's, you know, we had some structured conversations in front of people with robes. Yeah, they occasionally abuses happen. Okay, so if we need to have some extra processes, we need to have some extra protections to guard against potential abuses. What would those be? What do you think? You're doing a great job, by the way, Nick.
The administrative would actually be canceled out by the judiciary branch in this case.
Okay, let's make really clear with our language here. It's the county commissioners, the board of county commissioners is the actor in both cases. So it's what kind of hat they have on. This is what's the confusing thing about being in front of local government, whether you're a planner or a developer or a lawyer, because they wear so many different hats. And sometimes they're legislators, and sometimes they're administrators, and sometimes they're judges, right? And those roles are really different, and that's what the court's trying to emphasize here, is that those roles are very different, and they have very different rules. And if you mess up on it, people get hurt, and the courts get angry. And so they're trying. This is a kind of a teaching moment to local governments to say, okay, be really clear on what kind of action it is that you're taking, and making sure that you follow the necessary rules, so that everybody's treated fairly. So there's the court saying, okay, this is a rezoning, and we frequently think of rezonings as being legislative actions, and in the state of Utah, they almost categorically are considered legislative actions. So just a little practice tip here. If you're in Utah, they kind of have this thing screwed up. We'll talk more about that next time. But what the Zoning Court is saying, let's be real about what kind of action is being taken here. And you can see in this situation, even if the title across the top of the page says rezoning, we still know what's going on here. We're taking an existing district, applying it to a single piece of property with just a few people affected. This walks like an administrative action, talks like an administrative action. We're going to treat it like an administrative action. And because it's an administrative action, we require that you, county, make sure that the people who are involved are treated fairly. And what does the court say about fair treatment? The minimum standards for fair treatment. You catch that? It's okay if you didn't.
No, I did not.
Okay. I think you all have the same page numbers because I scanned it from. It's 11:55. Yes, we are getting to that point of the semester. We're about page 1,000, even in this other book, which is, I don't know if the page number showed up in the scan. 1, 2, 3, 4, 5th page in the scan. And did the scan work okay? Could you open it all right? Yeah. Good. The bottom paragraph before you get into the long footnote, and about halfway through that paragraph, parties at the hearing before the county governing body are entitled to an opportunity to be heard. There has to be a hearing at which that a hearing is not equivalent to the noun meeting, right? A hearing is where what? There is an opportunity for people to testify. So at the hearing, opportunity to testify for whom?
Testify in behalf of the applicant and in behalf of the people who are opposing the law as well.
What if, I got my training in Oregon, did my professional practice in Oregon, child was born in Oregon. I've got some emotional connections to it. So I still do. I haven't lived there for 15 years. What if I showed up at the hearing? It's manufactured housing. This is a mobile home park. This is horrible. This is a scourge on the landscape. This has to stop right now. Do I have the right to testify?
Yes.
Why?
Yeah.
Because I showed up. Now, they might allow me to testify. That's not what I asked. Do I have the right to testify? Why not?
You're not involved in
Yeah.
we can talk about it, they can listen to you, but
Parties have rights. People who show up might be accommodated. But that is an extension of a privilege. It is not an assertion of a right. Parties have due process rights. So kind of one of the elements here, and that this sentence starts that way. Parties at the hearing. All right? That is not equivalent to people at the hearing. And as Ed said, parties, people, how do you know the difference? When is a person a party? When they've got a funny little hat on and a drink in their hand. No, when they have a dog in the fight, to use a colloquialism for those who didn't grow up in this culture. It means you've got a real stake at issue, right? A particularized interest is what the Supreme Court says. I'm talking about who's a party. A particularized interest meaning that it's not just a generalized concern. like mine is, for the environment in the state of Oregon. It's, you own land, or you rent land, or you're gonna be affected, potentially affected by the project. How do you define that? Well, it depends. It's defined based on the facts of any particular circumstance. Mobile home manufactured housing development. You know, how far out do those effects go? Certainly to the surrounding property. How much further than that? Well, I don't know. It depends. If Thiokol is building a new rocket engine plant in your neighborhood. Thiokol, they're a big employer here in Utah, and they build rocket engines for NASA, for the space shuttle and other rockets and so forth. If they're building a new rocket engine plant in your neighborhood, you expect the potential impacts might be a little bit bigger. Yeah, your definition of parties would probably be much broader because the range or the geographic extent of potential impacts would be bigger. The impacts will vary with the circumstance, but the idea here is that people who have rights under the due process clause, in other words, who are parties, are people who have real interests, real defined interests at stake. And it isn't always negative. I mean, a potential project that's coming in that could have a positive impact on your property values, for example. What would that be? I'm only coming up with a negative example. This just shows you my mood. Grocery store in the neighborhood. You're not living right next door. You might not be, if you're living right next door to a proposed new grocery store, maybe not so a cherry on it, not so in favor of it. But if you're a block away, having that grocery store in your neighborhood could make your house a lot more valuable by having that kind of proximity to shopping. It could make your house more valuable. It's more easier to sell if you had to sell it for a higher price. So you have a real defined interest that's at stake with whether the grocery store happens or not. You could be considered a party. You'd be there arguing in favor of it, trying to convince the decision maker to approve this application, right? Okay, I think I've beat this one to death. What else do you need in order for this to be real, to be effective?
Them to allow to present evidence and refute evidence.
So you need to testify, and not, it's not just a matter of standing up and saying what you think, but also to present evidence. And this is for proponents and opponents. It's not just for applicants. And to rebut evidence and testimony that's provided by other parties. Everybody gets that chance. But to make this thing official or effective, what else do you need?
Impartial.
Yeah, but before that, Jared. Notice, yes. And this White Miriam had you go through, spends a lot of time on notice. And the reason he does is because it's pretty technical, the rules, the notice rules. And if you get it wrong, you have a number of examples there where people have gotten it wrong, it can have dire consequences for a potential project. So you got to know that the hearing is going to happen, right? So it's not just having a hearing is not enough. There has to be notice. And how far, how far do the notice ripples have to go? Who has the right to notice?
Everyone within a certain distance or that would pertain to this thing. So, like,
Anybody with a real defined interest that's potentially at stake. Again, statutory law, in this case, and local ordinance provisions will define the notice requirements for any particular action. So for Tuesday, this isn't assigned yet, but please, for Tuesday, go through the zoning ordinance, through the Salt Lake City zoning ordinance, there's a whole section that's just, I believe, if I'm remembering this correctly, there's a whole section just on notice. And it's, oh man, it is more boring than watching paint dry. But just kind of scan through it to see what's there, and you get a flavor for what the notice provisions say. When you have to do one of these things, you'll get in there, you'll figure it all out, and work out all the details, and you'll know exactly what needs to happen. But just to get a kind of a flavor for it, read the Salt Lake City zoning ordinance on notice. There was a hand. I saw one. No? Yes.
For example, in the case here, what about the people who are going to rent the houses, like the workers, are they entitled to attend these meetings?
Do we know who they are? Usually not. Because and these kinds of, especially these kinds of projects, don't pre-rent or they're constructed, right? And manufactured housing, if you're a developer, what you're really creating is you're creating sites that people can bring a manufactured home to. And so the people who are renters, but they're renting the ground. They own their unit. So that's not going to be difficult. But clearly, there are some other interests that are not being represented here, and your point's well taken. That even with these kinds of protections, not everyone who has a real interest is going to end up getting noticed and have the right to have a say. And so it's an imperfect system, but it's better than many other alternatives. So someone said, maybe, that we wanted to have an unbiased decision making, right? That's right. If you are, let's say you've been arrested for some minor infraction that amounts to only a misdemeanor, and I won't make up. It could be for anything. It's not going to do. Use your imagination. You come up with the example. Darn it, I've been doing it all semester. I'm tired. So you've been arrested. It's a misdemeanor. It could be jail time, or it could be just a fine. You go before the judge. Judge finds you guilty and is about to sentence you. How good do you feel about this whole process and about the thing that's going to come out of the judge's mouth? If you know that the judge owns shares in a company that runs a private prison system that has a contract in your state. There are such companies. I hope to God we don't have judges out there who are shareholders. But you get my point here, right? You don't want the person who's making a decision. Again, on the legislative side, we don't care or don't care as much about potential conflicts of interest. We do care some, but we don't care as much about potential conflicts of interest because it is such a public process and it affects a large number of people and a lot of land. And so the system is designed to try to check or guard against that through the political electoral processes. But when it comes down to judicial decisions or quasi-judicial decisions or administrative decisions, when it's just you and the Board of Commissioners or the City Council or the judge, boy, you want that person to treat you fairly, don't you? And you want them to be unbiased. Now, we had a case at Thousand Friends. I think I've talked about it. Did I tell you the story about Rajneesh Puram? Oh, you didn't know that. The Bhagwan Sri Rajneesh was a mystic, charismatic person from India who had, I didn't spend time trying to figure out what his religious beliefs involved, but he accrued to himself a group of followers. And they were by decree were all dressed in orange and red. It's colors of the sunset. They were a colorful group. And they had certain religious practices and beliefs and so forth. And they were. And they wanted to have their own ashram. And they decided that Wasco County in north central Oregon was just the place to do it. They bought a ranch and started building their ashram, which was really a town for about 10,000 people. They never got a single permit. Not a one. So we decided, as being a nonprofit organization that is trying to enforce the Oregon land use laws, we could just take them off. These are people who had caches of automatic weapons stored. And when I said cult, you probably saw, various descriptions of what a cult is. They threatened people. They sent salmonella poisoned food to people. We got a box of chocolates. Where's this from? Somebody's about ready to eat one. No, stop. We had to test it. Oh yeah, it's got salmonella. So they, after getting, shall we say, red tag for the construction of their ashram, cease and desist order, they decided for a while that they were going to try to get right with the law. And so they applied to the Wasco County Commission, Board of Commissioners, for the incorporation. So they were going to incorporate as the town, and then they would have the control of their own zoning and so forth. And so they filed the incorporation papers, and the Board of Commissioners, 3 of them, are required to vote by majority to approve the incorporation in order for that to take place, and they become their own municipality and take care of their own business. Wasco County, it's the county seat is the Dalles, which is on the Columbia River. It's east of the mountain. So if your image of Oregon is one of kind of verdant green fields and pine or Douglas fir forests, this is not that. This is on the other side of the mountains. It is very dry. It's high desert. It's pretty much like what you see at the window here. It's ranching country. And the old boys, and they were, who are on the Wasco County Board of Commissioners, are all ranchers. And so somebody at the ashram decides, it might be a good idea to buy, we need to raise our own food here. Let's buy some cattle. Yes, because we're not vegetarians. Let's buy some cows that we can raise and then slaughter and use meat, whatever. And so they contact a local rancher. Oh, it just happens to be one of the members of the Wasco County Board of Commissioners. And they, I don't remember what the going price was for a head of cattle at that moment in time, but let's say it was $1,000 per animal, and they offered them, well, we'd like to offer you $10,000. It was some hugely, just obscenely inflated price. And then the rancher said, oh, that sounds like a good price. I'll take that. And so the transaction happened. And it was all documented. We had the smoking gun, as they say. We had all the proof. And we submitted it. And we said, hello, this is a administrative action, right? Unbiased decision maker, and we lost that case. The reason we lost that case is a doctrine, it's called the doctrine of necessity. And the doctrine of necessity says even with a substantially flawed process, if you have to have that person make a decision, then because it's necessary, then it's going to go forward even if it's flawed. And this is the Oregon Supreme Court talking. They said, you got to have 3 people voting. You can't have just 2 people voting. And so they said, this still is legitimate. This still goes forward. And so Why did I tell you that? To make you all cynical? No, because it's a great story. But to say that this is an aspiration, but sometimes if there's, you only have certain people that can make decisions, even if they're biased, sometimes they still make the decisions. It's still legal. But at least we aspire to have fair decisions. Okay, so what's our last element here?
Reasonable outcome.
A reasoned outcome, not necessarily a reasonable. Lord knows. We get a lot of outcomes that are not reasonable, but a reasoned outcome, in a very good sense. And what does a reasoned outcome mean?
It's not arbitrary or capricious.
Right. Not arbitrary and capricious. Okay, so let's define that.
They have an explanation and a reason behind why they came up with their decision.
Right. Let's say, using the example from the midterm, because that was an administrative action that the Planning Commission took, right, with respect to that conditional use permit for the proposed new store, right? Administrative action. They had a hearing. We assume there was notice. Some people tried to make that an issue. There weren't facts there, but they had a hearing. We don't know whether they were biased or not. We'll assume the best and say they weren't. And then they decided to deny the application. And I don't know that the facts don't tell us whether they wrote down the reasons for their decision. But let's say they did. Let's say they wrote out, I don't know how long it would take, maybe just a couple of sentences, but they said, everybody that came to the hearing spoke against this proposal. That is the reason for our decision. Does that meet your standard?
I'd say no. I think there needs to be a little bit more substance to it. Just because people complain doesn't mean that it's not necessarily a good deal.
Right.
Maybe better for the health, safety, and welfare of the community. It may advance some certain cause or reason behind why they're doing it. I think that's really, it needs to be more based on those sorts of things rather than just totally based upon what they think.
It needs to be based on applicable criteria, is what I hear you say. You agree?
Yeah.
Yeah. So, and were the people who showed up and testified against the proposed application in that example, were they speaking to criteria? Remember that the element from this was in there intentionally. Each one of them got up and said what?
Oh, from the midterm.
Uh-huh.
They got up and said that just we don't want this store here. That's it.
Yeah, that's all they said. And maybe, we don't know, the facts don't tell us, maybe the zoning ordinance has listed as a criterion for conditional use permits that everybody wants the permit to be issued. Everybody likes the permit. Everybody likes the application, and that could have been a criterion. We don't know, maybe that was in the zoning ordinance, probably not. Right? So, with a reasoned outcome, this is key. We are demanding, the Constitution is demanding, that we have evidence of criteria being applied to the decision that are applicable, meaning that they are specified in some other body of law, the zoning ordinance. And that the decision being made is being made based on those criteria. Right? What else do we know? Let's say you've got 5 criteria. The criteria are that the new project will not unduly burden the surrounding roadways, that there's adequate capacity in the sewer systems, that there's adequate water, to set aside that there's a capacity in local schools to be able to handle the children that will live in this project, and that we've got enough open space to accommodate little kiddies on the weekends. Those are the 5 criteria. We've got an applicant that comes forward with a project. Let's say the manufactured housing project. They fill out the form, but they don't provide any evidence on any of those criteria. Should the county approve the application? No, because there's no evidence. Right, so we don't. We want the decision maker to tell us what criteria that they are using in making their decision, and we want them to tell us what evidence they are relying on in making their decision. Or if there's no evidence or inadequate evidence, they're telling us that. So what is our evidentiary standard?
On this case,
How much evidence? We've got 5 factors. Well, not in any case. Stay with my hypothetical here. We've got 5 criteria. How much evidence do we need to provide to satisfy the Constitution?
okay.
Yeah, you gotta have something on all 5. How much on each? Yeah, that's the right constant. Substantial evidence. And we know substantial evidence is how much? More than a scintilla. Enough to satisfy a reasonable person that the criteria have been met. So for those 5 criteria, we need enough evidence on each point to convince a reasonable person that the criteria have been met. It's not actually very much. A scintilla is a wisp of smoke, so it's more than nothing, but not a heck of a lot. Certainly not beyond a reasonable doubt or preponderance and other things. And it's these 2 combined that leads to the decision. Do you already see a parallel here with an exercise that you just went through? It was so unpleasant, and you've had some time to think about it over spring break. Law, fact, result. Right? It's exactly what the due process clause is requiring for decision makers when they're making decisions on administrative issues. Right? Exactly what you guys did for your midterm. Identify the applicable legal principle. Identify the facts that have been presented to the decision maker. Blend the 2 and come to a conclusion. That's what the reasoned outcome means. Okay. Excellent work. Fabulous. Come on, give it up. All right. So, in the 10 minutes remaining, let's talk about Dwight Merriam. Kind of an entertaining writer, yes? And I hope where problems opening this file, it was big. Yeah. Did you persevere?
I just read it. The only way I could get it to pop up is in the little preview screen.
Oh.
So I just don't know what the preview screen is.
Okay. Good. Sorry, I worked with our IT guys. I said, how can I shrink this size? And he told me a couple things. It was 24 megabytes previously. It was Word.
But it worked.
Okay. So we're not going to go through it in detail. Like I told you, I just wanted you to kind of scan through it. A couple things that I want to highlight. We talked about the notice and the accession of notice, and details really are important. And presentation, most of this reading was really about how to, generally from an applicant's point of view, how you should prepare and then conduct yourself at a hearing on an application. And a lot of the stuff here is really drawn from, I don't know if he's doing this intentionally or not, but perhaps, is drawn from texts on public speaking. Your job when you are an applicant, or if you're an opponent, or if you're an advocate, you work on the planning staff and you're trying to convince your planning commission of the advisability of taking one position or another. Your job is to convince. To stand up, make a presentation, have the materials prepared in advance that will inspire the action that you want to see happen. It's rhetorical communication, because that's what rhetorical communication does. It tries to inspire people to do something in response to what you say. And how do you do that? Well, there are a lot of great examples here. Other ones that I might suggest to you, and I think maybe he touches on this, is you want your audience to kind of be with you, right? You want them to, when you're talking, you want them to be going, huh? You know, and to kind of, you want to be able to lead them on down a logical path towards what, by the time you get to it, seems like the inevitable result. Of course, there's really only one option here. Just exactly what Professor Bartholomew said. How do you do that? It's really the nature of storytelling. It's because that. Maybe you've read Stephen Jay Gould, the famous biologist. He writes that humans are the primate that tells stories. And when you think about it, that is how, for centuries, millennia, our species has transmitted information. It's through stories. And even today, you say, oh, well, we're much more modern now, and you're talking about, I have this image of people who are very hairy and standing, kind of stooped over around a fireplace, telling the stories. But we still do it, even with all of our technological advances and the priding of our intellect. We still tell stories, and that is some of the most effective ways for especially rhetorical communication. Example one, Ronald Reagan. Ronald Reagan was and he wasn't the first one, but he perfected this technique to such a great extent, and I really dislike the guy. But I had to stand in awe of his ability to be able to bring people along. And he got known as the great communicator, right? And what would he do? When he had an important policy issue that he needed to promote, he would tell you a story about someone, right? Not about a community, not about a state, not about the whole nation, for goodness sakes. That is just too hard for us to relate to. He would tell a story about a single person, right? When you go home tonight and you flip on the television, and if you're not watching the Jazz lose again, and they most certainly will against San Antonio, it's so aggravating. Then your choices, you might look through, okay, what do I want to watch? You're more likely to be watching what? Some television show that's going to be a story, what? About a whole group of people? No, it's going to be about individual characters, right? Why do we like that? Because we see ourselves in them, or sometimes we see ourselves as not being in them. Sometimes we like, I'm looking at somebody else's troubles, and that makes us feel better about our own station in life. But we love great stories about individuals and about people. And so a good presentation is using a narrative style that is really drawn from screenwriting and creative writing, expository writing sometimes, but usually creative writing. And it's about having individual characters that people can relate to, about situations that are comprehensible and maybe are shared by the audience members. I mean, watch a good comic. The people who make us laugh are the people who tell us things about ourselves, right? When they tell a story about, something that happened to them, they're really talking about something that might have happened to us, and that's why they're telling it. And when you laugh, you're laughing because, oh, I know that it is so hilarious, right? So situations that are familiar. So this is kind of the style of structuring presentation. The content is, as Miriam says in his book, you have an introduction that kind of lays out the basic themes of the proposal, and then this I don't think he hits this enough. Then you walk through those individual criteria, unless there are 50,000 of them. I mean, they're not usually. Usually there's 5 or 6. If you got 5 or 6 criteria, then you walk through each one of those individual criteria, and as you introduce each one of them, you talk about what it means, and you maybe say, and this is such an important concept for maintenance and order and livability in our community, and here is the information, here are the reports, here's the evidence that shows that we're meeting this standard. And you kind of march through it, one criterion at a time, and you get to the conclusion, and you tell another interesting anecdote you think might relate to your project and they can relate to, and then you say thank you very much, and you'd be happy to answer questions. So that's kind of the structure and the approach. The actual delivery is more or less doing what I'm doing right now, right? You think this works very well for you? Before the hearing is closed, you may wish to provide the board with draft findings of fact and findings of law. Findings of fact, right? Now, so read. Don't stand behind the podium unless you have to. Sometimes you have to. You want them to feel like they're interacting with you. You're interacting with them, and that means lots of preparation so that you can talk without having something in front of you. Or if you have something in front of you, it's just a single sheet of paper that maybe you just keep there as a prop. Sometimes people need props, things to hold on to. You ever watch Sports Channel on ESPN? Yeah, I figure a few of you have, yes. They are great at this. The best is Hannah Storm. Her use of a piece of paper is just masterful. She has in her hand, when she's standing up at the smart board there, she has in her hand, and it's usually rolled up like this. And she uses it for emphasis and to point at something, and she holds it there. Occasionally she'll read a fact or figure from it. Sometimes I think she's making that up just to justify having it in her hands. She really knows the number. But she is great at this, and she is really engaging. And so think about Hannah when you're making your presentation. Well, maybe not, but okay. So there's always a lot more we could say on this subject. We'll talk about it more on Tuesday, but we will move on because more or less we covered what we needed to today. So we're consent, yes. So there are 2 cases for Tuesday. They're both online. They're much smaller in size, Chrissy, so I don't think it should be a problem. All right, go to the lecture. Enjoy yourself.